Hello everyone and welcome to our final group projects video. Today we, Maria, Iris, Nofar, and Lina will present to you the Astronomer CEO incident. So, on the 19th of July 2025, several major newspapers, as for example BBC, published articles about the Astronomer CEO incident. A video circulating online showed Astronomer's chief officers attending a Coldplay concert together. This lately provoked a whole corporate scandal and escalated into a corporate governance challenge. This case shows how an informal interaction, which was considered a conflict of interests, exposed weaknesses in the director's duties within the corporation. In our project, we will firstly answer the question what happened, where I will outline the facts and present major corporate governance issues. We will later see how exactly it happened, where Lina will analyze the presented issues. And in the end, we will see what could have been done or what can be done, where Nofar and Iris will present possible internal corporate governance and broader reforms. There are 6 major facts that we had identified. Astronomer is an American technology company incorporated in the state of Delaware and headquartered in New York. On the 16th of July 2025, a video circulated online showing Astronomer's chief executive officer, Andy Byron, embracing a female colleague during a Coldplay concert held at the Gillette Stadium in Massachusetts. The woman seen in the video was identified by public reporting as Christine Cabot, the company's chief people officer. After the video went viral, Astronomer announced that it had launched an internal investigation into the relationship in question and had placed the CEO on leave pending the outcome of the investigation. Mr. Byron then tendered his resignation as CEO, and the board has accepted it. Following the resignation, the board appointed the company's chief product officer as interim CEO and initiated a formal process to identify a new permanent leader. On Saturday, 19th of July 2025, Astronomer issued a public statement declaring, "Astronomer is committed to the values and culture that have guided us since our founding. Our leaders are expected to set the standard in both conduct and accountability, and recently that standard was not met." We later identified 3 key corporate law issues. Firstly, the fiduciary duties, secondly, Germark duties, and in the end, independence of the board.
Now that we've established the key facts of the scandal, I'll move on to the corporate law issues it raises and then show how each one of them applies to Astronomer. So first we have the issue of fiduciary duties, and especially the duty of loyalty. Under Delaware law, directors and officers must put the corporation's interests ahead of their own. Ganter v. Stevens confirms that officers owe the same duties as directors, and DGSL Rule 102b7 highlights how central loyalty is by making it non-exculpable. The duty of loyalty is particularly important when personal relationships create the risk of self-interested decision-making. Second, there's the Germark duty of oversight, in which boards must implement reporting systems, monitor them, and respond to red flags. Germark cases traditionally involve compliance failures or mission-critical risks, but the broader principle is whether the board is supervising corporate affairs in a way that prevents misconduct. And third, the issue of board independence. Delaware doesn't impose a statutory requirement for a majority independent board, but independence is crucial for derivative litigation, as in Beam v. Stewart. Listed companies must also follow NASDAQ or NYCE independence rules. Beyond formal requirements, independence is also about whether directors actually receive the information they need to monitor executives. Now let's apply this to the specific context of the Astronomer case. For fiduciary duties, as a Delaware corporation, Astronomer's CEO and CPO owe duties of care and loyalty. Their undisclosed relationship creates a clear conflict of interest, especially in HR decisions, and exposes the company to reputational and legal risks. A prudent officer should have anticipated the potential damage once the incident went public. However, we still lack evidence of a specific corporate decision being influenced, so this is more a loyalty concern than a demonstrated breach. For Germark oversight, the key question is whether the board had appropriate policies for reporting executive misconduct or workplace relationships. If no such system existed, that suggests a failure to implement controls. If it existed but wasn't used, that suggests a failure to monitor. The board did react by launching an investigation, which weakens any Caremark claim, so the issue is mostly a governance weakness, not a legal violation. And for board independence, the board only learned about the relationship after the scandal became public. That reveals an information flow problem. Even if directors were independent on paper, they weren't receiving essential information from management. So the concern is not formal independence, but a lack of effective oversight.
Several internal governance reforms could effectively address the identified corporate law issues. Firstly, to strengthen the enforcement of officer fiduciary duties, one proposal would be for Astronomer to draw from the Caremark case and its standard of director oversight responsibility and establish a formal risk monitoring committee. In Caremark, the Delaware Court of Chancery stated that only a sustained or systematic failure of the board to exercise oversight, such as an utter failure to assure that a reporting system exists, will establish that directors demonstrated a lack of good faith. On its security page, Astronomer says that it maintains a security program with a security committee that meets regularly to review reports and material changes in the threat environment. However, Astronomer does not have a formal risk monitoring committee for internal governance, at least not one that is publicly disclosed. While Caremark concerned a board's failure to monitor legal compliance, the Astronomer CEO scandal was harmful more in the reputational sense. Therefore, it would be inaccurate to assert that Astronomer's board bears the same level of liability for lack of good faith through the lack of a reporting system. Nonetheless, Astronomer could adopt a risk monitoring committee to firstly reduce the risk of similar incidents occurring in the future, and secondly to protect the board from facing potential liability for a breach of good faith. A further proposal to address the corporate law concerns raised by my colleague would be to establish a formal conflict of interest procedure, specifically to oblige all senior officers to disclose any romantic, familial, or financial relationship with any other officer or employee. Importantly, disclosures should be submitted directly to the board of directors rather than through management. This solution remedies the officer's duty of loyalty problem by explicitly documenting that the corporation, rather than the personal relationship, guides decision-making. As in the case of Astronomer, the loyalty concern was derived from the failure to disclose the relationship as a potential conflict of interest to the board. Conversely, while this solution doesn't offer direct protection against an officer's breach of duty of care, it does reduce the risk of such a breach occurring by providing the board with the opportunity to reassign, terminate, or change reporting lines within the disclosed personal relationship. Moreover, mandatory disclosure bridges the gap between the board's formal independence and effective oversight. Under DGCL 144, directors and officers who have an interest in any transaction with the company have a safe harbor if the material facts of the insider's interests are disclosed or known to the other directors, and if a majority of disinterested directors authorize the transaction. While the scandal itself wasn't a transaction with the company, the continuation of the CEO's employment under a conflict of interest is a corporate decision. In this sense, having a mandatory disclosure policy protects the board's oversight by forcing the conflict of interest to be transparent, requiring a majority of disinterested, fully informed directors to approve the resolution, for example through reassignment, which protects the board's decisions under DGCL 144's safe harbor. Ultimately, mandatory disclosure addresses the key structural problem in this specific case's lack of effective oversight, that the chief people officer, the designated person for reporting this exact risk, is the same officer involved in concealing the conflict of interest.
Now we will continue by looking at the broader corporate law reforms. The first reform. Delaware law says that officers owe the same fiduciary duties as directors. But Section 102b7 allows only directors and not officers to be protected from monetary liability for breaches of the duty of care. In Astronomer, the reputational harm came from personal conduct by two senior officers. Even though it didn't involve bad faith or international wrongdoing, officers operate under a liability regime that exposes them more than directors for judgment errors. So the idea behind this reform is straightforward. If officers and directors have the same duties, Delaware could allow Section 102b7 protection to apply to officers for duty of care claims. This would not affect loyalty or bad faith claims. It would just make the system more consistent. The Astronomer case shows why consistency matters, because the reputational and cultural harm came directly from the actions of senior officers, not directors. This site focuses on legal compliance or mission-critical risks. But the Astronomer incident showed that cultural and reputational issues can also become significant for a company. In this case, the situation came to light only once it was already public. We do not know whether internal reporting mechanism existed or not, but either scenario reveals a governance concern. If no mechanism existed, cultural and ethical risks could fall outside the board's oversight simply because the system wasn't designed to capture them. If a mechanism did exist but was not used, that suggests a different problem. Information flow from senior officers to the board may fail even when formal systems are in place. Either way, the lesson is the same. Cultural and reputational risks are not always integrated into oversight practices. So the reform is for boards to explicitly treat these risks as part of the information they expect to monitor through committees, indicators, or regular reporting, not to expand liability, but to give directors the information they need to manage modern governance risks. Finally, our third reform. Delaware treats independence as a safeguard, but independence only works when directors actually receive timely and reliable information. In the Astronomer incident, public reporting doesn't tell us whether the board knew about the relationship before, but either possibility reveals the same governance weakness. If the board wasn't informed early, information flow from senior officers failed. And if the board was informed but didn't act, the formal independence didn't translate into effective oversight. So the reform is straightforward. Corporations should establish clear reporting channels that require senior officers to disclose conflicts of interest, conduct that could carry reputational risk, or other cultural concerns directly to the independence of directors.
In conclusion, this case is a reminder that good governance is not only a matter of legal compliance, but also of anticipating risks. The case revealed weaknesses in duty of care and loyalty of officers, in oversight duty of directors, and in questionable independence of the board within Astronomer Corporation. We think it could have been solved within the corporation by establishing a formal committee or a conflict of interest procedure, and on a broader level by aligning officer and director liability, treating reputation as a governance risk, and improving information flow. Thank you so much for your attention.